Hi, it's Mike DelSignore, Massachusetts OUI Lawyer. Today's video, I want to talk about Lawrence District Court, what happens, what you should expect if you face an OUI in Lawrence District Court. So I've been handling cases out of Lawrence for a long time. First court date, you're going to enter a not guilty plea. You get another date to come back for pretrial. So it'll take a little bit of time to get all the evidence we need to try to figure out whether it's a case you want to resolve or whether you want to fight. So the evidence isn't available entirely at the arraignment. We'll get a police report, but any video evidence takes some additional time to get. So keep in mind, though, if you took a breath test, you're over 0.08, you only have a 30-day suspension. After 30 days, you can get your full license back. So you'd be driving while we're fighting the case, waiting for the evidence. So if you failed the breathalyzer, breath test evidence doesn't always come into evidence. There's ways to exclude it from evidence so we can fight the case and hopefully still win the case. I've won cases all over Massachusetts for clients who have failed breath test results. There's a lot of errors in breathalyzer testing. There's a lot of different ways we can keep the test results out of evidence. So you're not left without options to still fight the case despite the breath test results being over 0.08. And if they're close to the legal limit, 0.08 exactly, 0.09, 0.10, there's additional defenses such as the margin of error of the machines that may apply to you that we can use in court to potentially win your case, even if the breath test results are known to the judge or jury. Now, if you refuse the breathalyzer, it's a 6-month suspension. After 6 months, you'll get your full license back, but in many cases, we'll be able to have the trial prior to the 6 months. Some cases, it may take longer. So 6-month suspension, if you're found not guilty prior to the 6 months, you can ask the judge to reinstate your license. So the benefit of refusing a breathalyzer is the government doesn't have the objective evidence of your BAC. So in other words, this is going to be a very subjective case. It's going to almost depend highly on field sobriety tests, the testimony about the driving, the interaction. So it's an opinion-based case. So there's a lot of reasons why an opinion may be wrong. An officer might think you were impaired based on your performance on the field tests. However, a lot of reasons why. Maybe you didn't get the instructions correctly. Maybe you have balance problems generally. Maybe you have a knee, leg, or back problem that the officer didn't know about. Perhaps the other officer was distracting you. Very common when I watch videos to see one officer distracting you during the test. Sometimes the backup officer might be given instructions. So you get two officers pounding you with instructions on these field sobriety tests, and it makes you nervous. Sometimes the ground is not flat or level. So these tests, there's a number of different defenses that I've used in court throughout the years to discredit the reliability of these tests. In many cases, I'll try to show that you basically passed the test, that the observations the officer is making to say you failed and are impaired are trivial and small. If you don't stumble, stagger, you go out 9 or even 10 steps, you come back, that's the gist of the test. Things like missing heel to toe, stepping off line slightly, while it's technically a violation or not doing the test perfectly, how are you expected to do these tests perfectly? You've never been asked to do them before. You're on the side of the road. You're nervous. If anything, what that shows is the government has a weak case. If they're saying you missed heel to toe, you stepped off line, things like that, it's not a major observation, and they have to prove the case to the highest degree of certainty. So keep that in mind. We don't need to win every little point for you to be found not guilty. Clients are polite, cooperative, respectful. It goes a long way to establish reasonable doubt. Often I'll be able to contrast different areas where in the booking, for example, you don't have any balance issues. If there's no issues with balance during booking, then it suggests that any issues with balance on the side of the road could have been just based on the unnatural condition you were put in. I'll try to minimize any claims of erratic driving to show that you're not impaired by alcohol. So if it's your first offense, if you lose, you're looking at typically the minimum penalty, 45-day license loss, being placed on probation. The standard plea is similar. You'd get a continuance without a finding, and then 1 year probation. So if you are charged with a first offense, it's a misdemeanor, you want to know what your best options are. Call me. I've been doing this for over 20 years. My name is Mike DelSignore. I'm happy to share my experience with you. my knowledge of Lawrence District Court to help you make the best decisions for yourself when charged with OUI.